Hi, I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City. And in this video, we're continuing our series on the E-2 investor visa by focusing on what is called the marginality requirement. In summary, this is the requirement that the E-2 business must create jobs for U.S. workers. This is often one of the main questions in the consular officer's mind. In fact, the marginality requirement is so important that it's possible to overcome other weaknesses in an application if the consular officer is convinced that the E-2 business will generate jobs for U.S. workers. Before we dive in, if you're interested in more information about the E-2 visa requirements, we've posted to our YouTube channel our full webinar on the E-2 visa. We also share a lot of free information about the E-2 visa and other visas on our blog. We'll link to both our blog and our YouTube channel below. Finally, please remember that no video or blog post can replace the value of working directly with an immigration lawyer who can navigate the specific nuances of your application. So, with that, let's talk about the marginality requirement. In the government's words, an E-2 business must be more than marginal. This means that the business must have the present or future ability to generate enough income to support more than just the E-2 investor and their family. Put simply, the E-2 business must employ U.S. workers. But when must the E-2 business employ these workers, and who counts as a worker anyway? And how can a startup that hasn't generated any revenue convince a consular officer that it will, in fact, employ people? These are all common questions and very good questions that come up in the process of preparing an E-2 investor application. Fortunately, it's not necessary for the E-2 business to employ workers before the E-2 application is submitted. In fact, the regulations state that a business can satisfy the marginality requirement by showing that it has the capacity to generate jobs within 5 years from the date the business begins normal business activities. This hiring should ideally begin earlier in the 5-year period rather than later, and should certainly occur before the E-2 investor applies to renew their E-2 visa in year 5. In terms of the number of employees that should be hired within this 5-year time frame, we generally recommend that the E-2 business employ at least 3 to 4 full-time equivalent workers. Workers, though, come in all forms, from independent contractors to W-2 employees. So what counts as a worker for E-2 visa purposes? It's helpful to imagine a spectrum. At one end of the spectrum is the best option, full-time W-2 employees. These are the government's preference, and having W-2 employees greatly strengthens an E-2 application. This is because W-2 employees tend to be longer term than other workers, such as independent contractors. W-2 employees are also usually provided certain benefits, like health insurance or retirement benefits, that are not available to independent contractors. Moving along the spectrum, we next find part-time W-2 workers. Part-time W-2 workers are not as compelling to the government as full-time W-2 workers, since part-time work tends to be less stable than full-time work, and the benefits that come with part-time work are typically less than those that come with full-time work. This being said, part-time W-2 employees are still very persuasive in an E-2 application, and they may be the only option for those businesses that are structured on part-time positions, such as, for example, a coffee shop or a yoga studio. Do keep in mind that the E-2 business should aim to employ at least 3 to 4 full-time equivalent workers within 5 years. Since full-time work is defined as 35 hours per week, it could require 2 or more part-time employees to perform the work of one full-time worker. Moving further along the spectrum, we find independent contractors, or 1099 workers. Independent contractors are not as compelling as W-2 employees, whether part-time or full-time. This is because independent contractors are often temporary, and they receive few or no benefits from the business in most examples. As a result, it is recommended that the E-2 business aim to employ W-2 workers and not to solely rely on independent contractors. Independent contractors are, however, better than no workers at all. If the E-2 business relies on independent contractors and does not lend itself to W-2 employees, it's important to show that the business provides work for a number of independent contractors and that their professional relationship to the E-2 business is long-term and ongoing. A couple additional notes. First, the E-2 business does not need to continue hiring once it has satisfied the marginality requirement. In other words, once the E-2 business employs at least 3 full-time equivalent U.S. workers, it's generally not necessary to continue hiring more. It can also, at that point, choose to utilize part-time employees or independent contractors, or more full-time employees if it wants to. On the other hand, if the business is applying to renew its E-2 visa, but it has fewer than 3 workers, the application would have a much better chance of being approved if these workers were full-time W-2 employees rather than independent contractors. So let's talk a bit about what a U.S. worker is. The E-2 visa application asks for information about the immigration status of those who work for the E-2 business, including whether the workers are U.S. citizens or are in the U.S. on work visas. Keep in mind that family members of the investor generally do not satisfy the marginality requirement. The E-2 investor's spouse can work for the E-2 business, but they would not count toward the 3 to 4 worker requirement. So the investor would also want to employ U.S. citizens and permanent residents. We mentioned before that the business can satisfy the marginality requirement by showing that it has either the present or future capacity to generate jobs for U.S. workers. What kind of evidence should be included in an application to show this? To show the present capacity to employ U.S. workers, the business can include corporate tax returns and payroll records that show how much the business generates in income, how much it pays in compensation, and how many employees it has on its payroll. For a startup, the business plan is absolutely essential to show employment projections. A well-constructed business plan will provide 5 years of financial projections that are rooted in reasonable assumptions. It will also show how those financial projections will make possible the employment of workers in the future, and how the work generated by the business will make these positions necessary. When deciding whether you will prepare the business plan yourself or hire a company to do so, keep in mind that the business plan for an E-2 visa has a very specific audience in mind: the consular officer. As a result, it's important that whoever prepares the business plan be able to anticipate the questions that the consular officer will have and frame the business plan accordingly. In addition to the business plan, the E-2 investor applicant with a startup business can also include a letter from the local Chamber of Commerce or other similar organization located in the community where the business will operate that speaks to the role the business will have in the local community and employment opportunities it will create. Also, if the E-2 investor plans to immediately hire workers, they should be able to point to working capital that's available to pay these workers. For those E-2 investors who are not operating a startup, there are also several important points to keep in mind. First, be careful if you've operated a similar business abroad but did not employ workers. Similarly, if you're buying a U.S. business for an E-2 visa, find a business that has employed at least 3 employees. The reason for both of these points is the same. It'll be difficult to explain to a consular officer why a business that has not employed people in the past will suddenly begin doing so just because it has a new owner or will now be working in the United States. Unless the E-2 investor is planning to implement substantial changes to the business, this could be a difficult obstacle to overcome. The marginality requirement can oftentimes make or break an E-2 application. Fail to convince the consular officer that the business will employ U.S. workers and you risk a denial. Or show the consular officer that the business is already employing U.S. workers and other aspects of the application, such as a low investment amount, could be less important. We hope this video about the E-2 visa's marginality requirement was helpful. If it was, please click the like and subscribe buttons below to stay updated on future videos about visa options and travel to the U.S. Thank you for watching.